Hello. Have you ever bought a car and someone has told you, oh, it's a good car? And then you take it home and you find out it's actually not a good car. Well, in today's session of Legal Grounds Live, I'm going to discuss the difference between puffery and misrepresentation. Thank you for joining me. My name is Benjamin Sanchez. I'm an attorney in Houston, Texas. I represent consumers and everyday problems, including homeowner disputes, foreclosures, evictions, bad car sales, you name it. If you're a consumer, I can help you. Now let's get on with today's topic. Many times, and this doesn't happen just in car sales, but all sorts of situations, consumers are being sold to by salespeople who say things that really aren't true. However, they say them in a way that does not allow them to have legal liability for what they say. In this vein, we call that puffery. So, what does puffery mean? Basically, puffery is when you say something that is an opinion or very vague, something that cannot be measured. If a salesman says something that's mere opinion or cannot be measured, then it's really going to be too vague to be actionable. I have looked up some cases and I just want to give some specific language. So some of the courts of appeals in Texas have said this: to be actionable, a representation must be specific enough to have a meaning against which its truthfulness or accuracy may be measured. If the representation is too vague to be measured, it may not be the basis of a DTPA complaint. The DTPA is shorthand for the Deceptive Trade Practices Act, and that is basically the big consumer law in Texas that allows you to sue under a number of different theories whenever there's a bad consumer transaction. A lot of it has to do with misrepresentation in various respects. So if someone says, this is a good house, you can't really go after them. If someone says, this is a great car, that's an opinion and that's very vague. Some examples of things have been found to be too vague are when a salesman says that we'll protect their interests or we'll protect your interests. That's too vague. What interests are you protecting? How are you going to protect it? The courts have found that to be too vague. Another example is, oh, well, this has been well managed. It may be a company, it may be a project. Well, what does well managed mean? You can't really measure that against something. So well managed has been held to be too vague. What also has been held to be too vague is quickly resolved. A quickly resolved is what type of quick are we talking about? When you go to a repair shop and they say, oh, it'll be done soon, or we're fast about our repairs. Again, that is too vague to be the basis of a misrepresentation claim because we don't know what soon means. We don't know how fast, what fast means in that context. Now, sometimes the court will say that a general term may end up being specific enough to be the basis of a claim if you look at the surrounding facts, right? So if there are other conversations or other representations made, and then that general representation is made in connection with those more specific terms, then the courts have held that that can be specific enough for a claim when that representation would not be specific enough on its own. So sometimes you have to look at the context. So for example, if you ask someone how if the transmission is in working order or is new or something like that, and then they say in response to something like that, oh, it's good, and you end up having a bad transmission, that may be actionable. The problem is too many times people ask general questions instead of specific questions. They ask, "How's the car?" Salesman says, "Oh, it's great. It's good." "Oh, is it drivable?" "Yes, it's drivable." And sure enough, you can drive off the lot with it, but you may have 50 miles down the road not be able to, and check engine light may come on or something. The other thing is that, again, opinion and belief are not generally actionable. A salesman's opinion about a car, um, you having a general belief based upon sort of what you think about the car is not going to be actionable. We talked about yesterday how to deal with Carfax, and a lot of times people form a belief about a car based upon Carfax, and then they want to hold the dealership liable or the car lot liable for that belief when it was not the dealer or the car lot salesman who did anything to create that belief. Now, when you have car repairs, or let's say you go buy a car, you find out there's some things wrong with it. You and the salesman agree that some work will be done to the car. And that basically is done to incentivize you to actually buy the car. So you buy the car. If the work is not done, then that is a misrepresentation and can be actionable. Not only is it a breach of contract, but it is also a misrepresentation because it was a specific representation made to you during the course of you trying to purchase a vehicle or shopping for a vehicle. So I'd kind of, the big takeaway is this, is if there's an opinion or if there is a statement made that is too vague to be measured for its truthfulness, then that is going to be considered puffery and not actionable under the Deceptive Trade Practices Act, and generally not actionable at all. However, if specific misrepresentations are made, then those are actionable. It could be fraud. It could be potentially negligence if there's no intent. It could be misrepresentation under the Deceptive Trade Practices Act. So there are a number of things. The best thing to do is to ask specific questions. Now, a lot of times people really don't know what to ask, right? The big takeaways, as I've said earlier this week, is to definitely have your own mechanic look at that car before you buy it. But while you are talking with the salesman, you should be asking specific questions. And if the salesman will probably do their best to make you think that they're answering your question when they're really not. They may give you a vague answer that's not specific. They may change the topic. So you really have to listen. That's one of the things that attorneys are taught during law school, is to really listen and pick apart the words that someone uses, because oftentimes when I ask a question, I will notice that someone's not really answering that particular question. So you got to get really good at asking specific questions and know the difference between a specific misrepresentation and mere puffery or opinion. Hope this has been helpful. This has been another edition of Legal Grounds Live. Benjamin Sanchez. Have a great day. Bye-bye.